Captions check, 1, 2, 3. Captions check, 1, 2, 3.
Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, November 6th, 2024. The time's 9:30 a.m. With us today are Commissioners Bobby Ginecca and Katerina Gonzalez, as well as our General Counsel, Mary Smith, and I am John Neerman. Registration has closed, but if you'd like to address the Commission, I'd invite you to please visit our registration table or email agenda@tceq.texas.gov. Identify yourself by name, your affiliation, and the item that you'd like to speak to, and we will do what we can to accommodate that request. For those addressing the Commission, our General Counsel or I will let you know when it's your turn and inform you of your time limits. I want to thank everyone for being present today, and Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the petition for the creation of Lampasas County Municipal Utility District Number 1 and request for additional road powers. The order of presentation will be the petitioner, protestant, ED, and then OPIC. Petitioner and the protestant will each have 10 minutes of oral argument time, while the ED and OPIC will each have 5 minutes of oral argument time. The petitioner may reserve a portion of its time for rebuttal as the petitioner bears the burden of proof in this matter. And so with that, we'll call the representative of the petitioner to the podium.
And sir, I'll have you double check that microphone and just make sure you have a green light. Okay, yeah. Good morning, go ahead when you're ready. Mr. Hamala, I'm sorry. I just want to make sure we're picking up your audio. I can hear you fine, but I can't tell if the mic is picking you up.
It's supposed to be a bright green light.
Okay.
Sorry about that. I'll start over.
Yeah, go ahead.
Okay. Good morning, Commissioners. My name is Richard Hamala, and I'm here with Jeff Kirschbaum. We represent the applicant, Pit Creek Ranch LLC. The applicant's manager, Prim Kaladindi, is observing the proceedings remotely. And I'd like to reserve 5 minutes of my time for rebuttal, if that's okay. I'll start off with saying that we're requesting that y'all find that the applicant has met its burden of proof on all evidence required to support the creation of the proposed municipal utility district. We disagree with the proposal for decision by the presiding SOA ALJ recommending denial because we feel like it's correct on 2 significant issues. First, in concluding that the district project is not feasible, the SOA ALJ applied an incorrect standard for the timing of construction cost estimates. The SOA ALJ considered cost estimates that were prepared more than a year after our application was filed and faulted the applicant for not analyzing that post-application data. And the ALJ incorrectly relied on that mistimed cost information and possible interest rate increases to conclude that the applicant failed to show reasonable tax rates. Also, the ALJ faulted the applicant for not evaluating the reasonableness of Corks Utilities water rates, which will apply within the district. And those rates are set by the Texas Public Utility Commission. They're not rates of the district. And then second, in determining that the project is not necessary because of a lack of market demand, the SOA ALJ assigned more credibility to anecdotal evidence presented by the protestant whose witness had no market study experience, and as compared to the applicant's market study evidence, which was prepared by a housing industry expert in line with TCEQ guidelines for market studies. We feel that both of these sets of PFD fact findings and conclusions were wrong. On the other hand, the SOA ALJ correctly recommended that the applicant met its burden of proof on many other matters. The applicant requests that the commission change the SOA ALJ's erroneous PFD findings and approve the applicant's request for district creation. A little bit of background on the district. This is a little over 2,900 acres of land in Lampasas County in a rural area. The plan is to develop into 421 large acreage lots. And the district is located in the CCN of Corks Utilities, and residents in the district will receive water service from Corks and will be charged rates by Corks Utilities. On the issue of estimated construction costs, the water code requires the applicant to provide cost estimates as part of its petition and application. And in our application, indeed, had cost estimates that were submitted at the time the application was filed. The protestants provided cost estimates that were developed more than a year after the application was filed. And in this case, we're just really requesting the commission to follow its decision in July of 2024 in the Ellis Ranch MUD case, where it concluded that a difference of opinion on construction cost does not render the applicant's estimated costs unreasonable. In fact, the ALJ admitted or concluded that the applicant's costs were reasonable at the time the application was filed, and there was no evidence to the contrary. On the market study demand issue, the only market study admitted evidence was the applicant's market study. The protestants offered anecdotal evidence that older homes in Lampasas County were less expensive than the value of homes projected by the applicant's market study. The applicants did not do a market study that aligns with commission guidelines. In contrast, the applicant hired a housing industry expert with years of experience and decades of data who submitted a competent market study that was prepared in accordance with commission guidelines. And one thing, older homes in a rural area are not going to be comparable to the cost of newly constructed homes with modern features and appliances. So we just feel that the protestants' market study evidence is not applicable to the creation of a district, which requires projections into the future. One thing as far as the necessity for the district, this district is needed. There is no city services available in this rural area. It's a common practice to have a district to provide financing for facilities and to provide an entity to operate and maintain those facilities. In order to obtain retail water service from Corks is requiring the developers or the owners to install a long transmission line, several miles, and the internal infrastructure. And the only way to finance that is with the district. There's no other entity that would be able to finance that. Otherwise, the homeowners would have to pay upfront those costs as opposed to being amortized over a long period of time.
That's 5 minutes.
Okay. And so I'll stop right there and save the rest for rebuttal. Thank you.
We have Mr. Allman for the protestants.
Good morning, Chairman, Commissioners, General Counsel, Executive Director, and the Public Interest Council. I'm Eric Allman, here represent citizens concerned, citizens of Lampasas County. Before you today is the decision of whether to impose a new property tax to create a new level of local government. The legislature has imposed certain considerations and requirements before that step is taken. One of those is to require that the applicant demonstrate a need for the project. Another is to demonstrate that the project is feasible. In this case, the executive director, the administrative law judge has properly found that there's not a need for this facility. There is a reason we feel like there's not a need for the district, in addition to the one identified by the administrative law judge. The administrative law judge has properly found that the construction costs estimated are not reasonable, and thus the project is not feasible. I will pause to say a bit about the role of an administrative law judge in making findings of fact. We do feel that the judge was in a better position to judge the credibility of the witnesses, was able to see their demeanor, was able to spend time with the evidence and with the testimony. And that's the role which SOA was formed to play, was to be an independent fact finder. And so we just would encourage you, just as an appellate court defers to the findings of a jury and trial court level, that it is appropriate on the need issue with regard to the demand for this district to defer to the finding of fact of the administrative law judge. And that is one of the reasons why there is not a need for this, is because there is simply not a demand for this. We presented testimony by Richard Petrie, who was a former chief appraiser there in Lampasas County and has significant experience in the area and still serves as a consultant to Lampasas County on the evaluation of properties. And as you can see in the handout I provided you,
This is in western Lampasas County. This is not near Austin or San Antonio or Dallas, as they say, would be the type of attractiveness that would draw people to this type of area. Mr. Petrie noted that. He noted that he simply did not see that type of market in this area in his experience. He's been working with this for many years. He didn't perform an entire market study, but an entire market study was not needed given the nature of the errors presented by the applicant. As Mr. Petrie noted, there have been only 12 homes sold in all of Lampasas County that were further away from major metropolitan areas than this proposed MUD. And this proposed MUD is only feasible if they sell 12 to 18 homes per year going forward. In addition, the assessed value of the MUD assumes is $850,000. The median property value in Lampasas County is $174,000. It's simply unreasonable to think that you're going to have homes sold at the prices which they assume. And if you look at the other side of the handout I provided, you will see that this is not large ranch type homes that are proposed. This is a fairly dense subdivision being placed in the middle of western Lampasas County. It's just not the area where there's a market for those types of homes. And the judge considered that and considered the reasoning of the applicant that, well, this is going to be regionally attractive to folks who want to be traveling to San Antonio or Dallas or Austin. And he commented that, Mr. Petrie stated that, I have not seen a willingness of buyers to purchase property in a town-like subdivision with a drive of 7 miles to get basic services and an hour or more to metropolitan shopping and entertainment. We think the judge's finding that there is not a need, given that there's not a demand for this, was appropriate and one that's appropriate for you to defer to. We will also note that we don't believe there is a need due to the availability of service for water from Corix Utilities. Importantly, this is placed within the CCN held by Corix for water service. The state has already looked at this and has already made a decision that there is water service necessary, and it's made a decision as to how that water service and who that water service should be from. That would be from Corix Utilities. We don't think that you need to take the additional step of imposing an additional property tax to provide water service that someone else already has the obligation to provide. When they say, well, Corix is demanding that certain infrastructure be put in place, that's not entirely true. What Corix has demanded is that somebody put that in place. Corix is perfectly fine if it's the developer. They're perfectly fine if it's the MUD. Corix has not said we need to have a MUD in order to provide water service. So we feel like that ask by Corix does not demonstrate there is a need for this facility. And then it is true that the construction cost estimates basically boils down to a question of whether you demand that the estimates be reasonable at the time of application or at the time of hearing. And we understand there have been some statements from the dais indicating that we at the time of the application. It's important for the commission to move forward on general policy through rulemaking, where it tends to apply things generally rather than simple comments from the dais. We would take the position. When we look at the statute, 54.021B requires findings that the proposed MUD is necessary and is feasible. We view that as a present tense requirement. Words added are assumed to be added intentionally, and the words not used are assumed not to have been used intentionally. If the legislature had intended an evaluation that looked backwards, then it would have said so. We feel like it is appropriate to make the information at this time as to whether need has been shown, is appropriate to look at the data at this time. And it was clear that prices have gone up tremendously. The prices associated with roads, such as concrete and pipes, are all significantly higher at the time of hearing than they were. And this is an area where there was no dispute. We asked the executive director and the applicant's witnesses, are they relevant now? And they said, we haven't looked at that because we don't think it's relevant whether they're reasonable now. Likewise, our witnesses said, they're not reasonable now. Yeah, they might have been reasonable at the time of application. So there wasn't really a disagreement as to facts on that issue, more a policy issue where we feel like if the commission is going to adopt a general policy, that should be embodied in the rule. We don't see anything in the rule that would require that. And for those reasons, we feel like the applicant has not demonstrated a need, for one of those reasons being the one that the ALJ find where it's appropriate to defer to the finding of the administrative law judge. And I will note that independently justifies denial of this application, independent of any finding as to at what time the construction costs are treated to be. And so it is perfectly an option for this commission to find that there's not a need based on the lack of a demand and put aside the issue of whether you're going to make a decision based on the reasonability of cost at the time of application or the time of the hearing you don't need to reach that particular issue to resolve that disagreement that the parties have. And with that, we would ask that you deny this application for a MUD petition. Thank you. I'm available for any questions you may have.
I have none. Colleagues, any questions? Seeing none, thank you.
Okay, that brings us to the ED.
Good morning. Good morning, Chairman, Commissioner, General Counsel, Public Interest Counsel. For the record, my name is Harrison Malley with the Environmental Law Division, and I am here on behalf of the Executive Director. With me today from the district section is Justin Tack. The ED respectfully recommends that the Commission issue the Lampasas County Municipal Utility District No. 1 order as drafted by the ED and create the district. The submitted petition complied with all applicable statutory and regulatory requirements. The ED recommends the Commissioners reject the proposal of the ALJ and the PFD and create the district. Pursuant to Texas Water Code Section 54021, the Commission shall consider the following factors to determine if a MUD should be created: the availability of comparable service, the reasonableness of projected construction costs, tax rates, and water and sewer rates, and whether the district will have an unreasonable effect on any of the following: land elevation, subsidence, groundwater levels, recharge capability of groundwater source, natural runoff rates and drainage, water quality, and total tax assessments on all land in the district. The ALJ concluded the applicant met all the requirements except for feasibility and necessity, specifically with proposed construction costs, tax rates, water rates, and the market need for the types of homes the applicant proposes to build in the district. In the ED's exceptions to the PFD, the ED reiterated that TCQ's rules under 30 TAC 293.11D require the engineering report submitted with the creation petition include tentative itemized cost estimates of the proposed capital improvements and itemized cost summary for anticipated bond issue requirement. The ED's witnesses testified that the engineering report met these requirements of the chapter and provided the district section sufficient information to conclude the district should be created. While costs may escalate over time, the critical issue is whether the costs were reasonable at the time they were submitted. Upon reviewing the costs, the ED's witness testified they were in fact reasonable, along with projected tax rates and water rates. Without a regulatory or statutory basis, continuous cost evaluations after a petition has been submitted create a moving standard for both the petitioners and the ED. Regarding the issue of necessity, the Commission shall consider all the criteria and factors set forth in 54021 to make its determination. In addition to the engineering report, the ED reviewed the market study, which the ED's witness testified complied with TCQ's rules. The ALJ concluded the proposed improvements to the undeveloped area within the district were a benefit to the district, as the creation is necessary to bring these practicable and beneficial improvements to the district, and the market study demonstrated a need for the proposed development. The ED's witness testified the district was necessary. The ED's position has remained the same since the technical memorandum for this application petition was issued. The proposed construction costs, tax rates, water rates study included with the engineering report were reasonable. As a result, the ED has found the district was feasible, practical, necessary, and would be a benefit to the land to be included in the district. With the remainder of the other district creation factors also being satisfied, the ED recommends that the Commission grant the petition and create Lampasas County Municipal Utility District No. 1. Thank you. We're here for questions.
None. Any questions, colleagues? Seeing none, thank you. Ms. Jamieson, good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jennifer Jamieson on behalf of OPIC. OPIC respectfully aligns with protestants and the ALJ and recommends denial of this petition as outlined by the ALJ's proposal for decision and amended by the exceptions letter. Specifically, OPIC agrees with the ALJ's analysis regarding consideration of post-application construction costs in evaluating the feasibility of a district creation. Both applicant and the ED cited to petition for creation of Highland Lakes Municipal Utility District No. 1 of Ellis County, where the Commission found that an approximate 35% increase in proposed construction costs since the preparation of the engineering report was reasonable. In Highland Lakes, Evidence showed that the project would cost approximately $30 million more than the originally estimated based on the increased construction costs. Here, the original construction costs were projected to be $51.5 million at the time of the application was filed and $82 million at the time the protestant's testimony was filed, an approximate 60% increase, or nearly twice the increase found to be reasonable in Highland Lakes. OPIC agrees with the ALJ and protestants that there is no evidence showing that construction costs remain reasonable under these current cost projections. Next, OPIC agrees with the ALJ that the evidence shows that the market study, when prepared, did not accurately reflect the Lampasas County market. The preponderance of credible evidence shows that the potential buyers of upper-end housing from outside the county would likely choose lower-priced property nearer to urban amenities in the eastern part of the county over land in the proposed district that is 7 miles west of Lampasas. Further, applicant's market study did not address the impact of Corex's rates or the cost an on-site sewer system would have on the housing market within the district. Accordingly, OPIC agrees with the ALJ and protestants that the preponderance of credible evidence shows that there is no realistic market demand for the proposed development. The market study is not reliable and that the market will not support an average home price of $850,000 in Lampasas County. As such, OPIC respectfully recommends denial of this petition as outlined by the ALJ's proposal for decision and amended by the exceptions letter. Thank you.
Thank you, Ms. Jameson. Seeing no questions, Mr. Hamala?
Thank you. Well, I'll start off with just the obvious. Y'all are not an appellate court. Y'all are making the decision today, and you're using the information in the record to make that decision. And with regard to Corex requiring the developer to put in these facilities, the developer has options on how to finance that. And one of the things that's allowed under Texas law is that a developer can seek the creation of a district to pay for water infrastructure, which is one of the primary reasons that the developer brought this application to y'all. There's a trend for people to move to smaller communities with be able to work remotely and the modern technology. And the developer of this project is taking advantage of that and hoping to create a master plan community in a rural area that will have the rural lifestyle. The risk on this does not fall on the future residents. The risk of the cost falls on the developer. Financing the reimbursements that can be paid by a district through bonds, or it's a retrospective analysis. You have to have the homes and the subdivisions created. You have to have the assessed value before that district can issue bonds and levy taxes to pay for those bonds. So that risk falls on the developer. It's not a burden on the future residents. When they do arrive, that they'll be paying their share of the cost of those facilities. And the district allows the concept of generational equity in terms of financing those costs over the time they're used by the residents at the time of use. And then the one thing to note is the protestants were concerned about the effect of this district on their groundwater. They provided no evidence of any effect on their groundwater. There was no evidence in the case of an effect on groundwater, and in fact, the whole purpose of having the Corex water lines installed, the facilities for Corex, is to bring water from off-site to this area, so there will be no effect on groundwater. And so with that, we would request that y'all grant this petition for creation of Lampasas County MUD number 1. We feel like the applicant has done everything that's required by your rules and the statutes to receive that creation order. Thank you. Any questions, I'd be happy to answer them.
Thank you, Mr. Hamala. I have none. Colleagues, any questions?
All
All right. Well, colleagues, here's my view. I believe the proposed order would create new interpretations, new policy, really, of what is required for MUD creation. These go beyond our precedent and ask more of the petitioner and of the agency than the statute requires. And I'm not ready to support this proposal for decision. First, I disagree with the ALJ's analysis of the reasonableness of projected construction costs, and I agree this is a matter of timing. I believe the better policy is for the commission to determine the reasonableness of construction costs based on the estimates at the time the preliminary report is filed with the petition. Otherwise, as was noted earlier, we have a moving target. It's difficult to assess the costs, and it's costly to assess the costs when the question of financial viability is going to be revisited later at the time that bonds are issued. So that's my view of a recommendation on the policy. It's the policy that we have traditionally followed. This petition, as well as the ALJ's findings, meet this standard. The ALJ's findings of fact on the projected construction costs at the time of the petition and preliminary report supports their reasonableness. Second, I disagree with the ALJ's determinations on the reasonableness of projected tax rates. The record shows that the proposed tax rate is collectible within the regulatory limits and in fact has room to move higher. Third, I propose to reject some of the ALJ's determinations on the reasonableness of projected water rates. I believe that the proposed water rates are reasonable because the applicant has proposed to apply the CCN holders approved tariffs rates within the district for service. The fact that Corix's approved rates are higher than an unrelated municipal system in the area does not render the petitioner's proposed rate unreasonable. Finally, the ALJ's proposed analysis of need and market demand is a departure from what the commission has considered in MUD creation matters. Historically, the commission has mainly used the statutory factors of considering the availability of comparable services from other systems to determine whether the proposed MUD is necessary. I do not believe that the commission's petition content requirements for filing a market study suggest that detailed market demand determinations are needed to create a MUD. And Galilee Partners is not precedential or persuasive because it involved a different type of district with different statutory standards. Colleagues, I think the record supports the creation of this MUD, and if you might be aligned with that view, I have a change document that would lay this out in greater detail, and I can circulate that. It also addresses the appointment of temporary directors. So what do you think? Commissioner Janeka?
I appreciate it. I think I largely agree with your comments as you laid them out. I'll just add on. I believe that the legislature has provided us with a difficult run-on sentence standard for creating a MUD without much express direction. I do find it important to fully consider the three groups of more specific factors that the legislature directed us to consider in making the MUD creation determination. I'm comfortable with the ALJ's analysis of the lack of comparable services in the area, but I struggled with how the ALJ analyzed the reasonableness of projected construction costs. The question of what period of time the commission should consider when determining if the projected construction costs affect the agency, potential developers, and the public in different ways. And I recognize the policy considerations on each side of the party's arguments. However, I find more policy support for establishing that the commission determines the reasonableness of construction costs based on the estimates at the time the preliminary report is filed with the petition. And the record evidence of the projected costs at the time of the petition supports a reasonableness finding. I disagree with the ALJ's determinations on the reasonableness of projected tax rates. I find it important that projected tax rate is within the regulatory limits within a cushion to go higher. I believe the timing of the review of cost projections also supports the collectability of the proposed tax rate. And I believe that the applicant supported the reasonableness of projected water rates for the district. The applicant has proposed to apply the CCN holders approved tariffs water rates within the district for service. I believe it's appropriate to give some deference to the PUC's approval of the rates to be used in this district. Comparing the rates between the CCN and a neighboring municipality was not persuasive to me. I also have significant concerns about the ALJ's proposed analysis of need and market demand. I believe that the statutory factor of considering the availability of comparable service from other systems is the appropriate factor for determining whether the proposed MUD is necessary. I believe that the ALJ has created a type of review outside the scope of what the legislature has directed. I too do not find the cited Galilee Partners matter controlling in this case because it involved a different type of district with different creation standards. In conclusion, I intend to vote for the creation of this municipal utility district and to grant it road powers. I'm also fine with the ALJ's proposed transcript cost assessment.
Thank you, Commissioner. Commissioner Gonzalez?
Much of what I thought has been said already. I largely agree with you, Chairman, about the different ALJ differences. I found it a little troubling that the ALJ seemed to propose almost an entirely new framework for what we typically do with these district creations, and I intend to vote for the creation as well.
All right, well, why don't we do this? Sounds like we're in general agreement, high level on the big issues. Let's circulate my change document. We'll take some time to review that and come back in just a little bit to see if y'all are satisfied with it. I have 10 o'clock right now. Why don't we take a 10-minute recess? And if you need more time, let me know. Again, it's 10 o'clock and we are in recess. We're going to take another 5 minutes, folks. 10:24, that break took a little bit longer than we anticipated, but we are back. And colleagues, let me ask you what you think of the change document. Commissioner Janeka.
I reviewed it and I'm in support of it.
Thank you. Commissioner Gonzalez.
I would just make 3 small changes for readability. For finding of fact 21, I would change the final finding to state the cost for 4-inch and 6-inch piping used for water construction were estimated at $35 and $55 per linear foot. And constructing a water plant to serve the 421 connections was estimated to cost $1 million, and the cost estimates contained in the petition. The ED testified that these estimates were reasonable, and protestant did not rebut these estimated costs at the time of filing the petition. For finding of fact 22, I would change the final finding to state the road facilities bond issue requirement was estimated to be $24.7 million. The ED testified that these estimates were reasonable, and protestants did not rebut these estimated costs at the time of filing the petition. And for finding of fact 28, I would add PUC to the approved tariff to emphasize that PUC approved that tariff.
All right. Thank you, Commissioner. Anything else?
No, thank you.
All right. I appreciate that. I now realize my drafting left a little bit to be desired, but I appreciate you cleaning that up. Colleagues, let me go ahead and offer a motion. I'm going to move that we adopt the administrative law judge's proposed order with the modifications identified in the document circulated at the agenda today, November 6, 2024, with the changes that Commissioner Gonzalez has just outlined, consistent with the remarks from the dais this morning. I further move that we grant the petition for creation of Lampasas County Municipal Utility District Number 1 and the request to acquire road powers, and that we appoint the individuals proposed by the applicant and recommended in the executive director's technical memorandum to serve as temporary directors until permanent directors are elected and qualified.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the application by Hill Country Waste Solutions LLC for new municipal solid waste permit number 2419.
So colleagues, we have 3 requests on this item. The Lees both fail to identify any concerns that could be referred to SOA, so we have to deny their requests. But Ms. Almeyer has met the procedural and substantive requirements to be granted a hearing. She's raised concerns about nuisance, surface water and groundwater quality, traffic safety, and noise. So I would refer her to SOA on those issues, as well as to our ADR program. Commissioner Janeka.
I agree.
Commissioner Gonzalez.
I'm in agreement.
I think we're ready for a motion.
I move that we grant the hearing request of Helen Almeyer, deny the hearing requests of James Lee and Ruth Lee, refer the matter to SOA for a contested case hearing on the following issues. A, whether the application and draft permit propose adequate measures to prevent nuisance conditions such as odor and vectors in accordance with applicable 30 Texas Administrative Code Chapter 330 requirements, including Chapter 330, Subchapter E, and 30 Texas Administrative Code Section 330.245, 330.543, and 330.63. B, whether the application and draft permit are protective of surface water and groundwater quality in accordance with applicable TCEQ rules, including 30 Texas Administrative Code 330.207 and 330.227. C, whether the applicant has adequately addressed traffic impacts and traffic safety in accordance with applicable TCEQ rules, including 30 Texas Administrative Code 330.61. And D, whether the application and draft permit propose adequate measures to prevent noise pollution under applicable requirements, including 30 Texas Administrative Code 330.239 and 330.543. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the application by Moore Farm Water Control and Improvement District Number 1 for new TIPD's permit number WQ 00162740001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, we have a single request on this item. I agree with the executive director and OPIC that the city of Terrell has a legal interest in this application and has met the requirements to be granted a contested case hearing. That includes raising concerns within our jurisdiction about need and regionalization, anti-degradation, water quality and the uses of the receiving waters, nuisance odors, notice, and the accuracy and completeness of the application, including whether it adequately identified the operator. So I would refer the matter to SOA on those issues. Again, I would include an ADR referral, and I would deny the request for reconsideration. Commissioner Ginecca.
I agree.
Commissioner Gonzalez.
I agree. Motion.
Ready for a motion?
I move that we grant the city of Terrell's hearing request, deny the request for reconsideration, refer the application to SOA for a contested case hearing on the following issues. Issue A, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under the Texas Water Code, section 26.0282, and the general policy to promote regional or area-wide systems under Texas Water Code, section 26.081. Whether the draft permit complies with applicable anti-degradation requirements. Issue C, whether the draft permit is protective of water quality and the existing uses in the receiving waters under the applicable surface water quality standards in 30 Texas Administrative Code, Chapter 307. Issue D, whether the application is accurate and contains all required information. Issue E, whether the draft permit adequately protects against nuisance odors and complies with applicable buffer zone requirements in accordance with 30 Texas Administrative Code, Section 309.13. Issue F, whether the applicant substantially complied with TCEQ's public notice requirements in 30 Texas Administrative Code, Section 39.405. And issue G, whether the applicant adequately identified the operator in the application. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number, item number 4 is the consideration of the application by Clear Utilities LLC for new TIPD's permit number WQ 00162730001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, we have dozens of requests on this item. I suspect for many people who are not familiar with our process. So let me recap the framework that we use for analyzing hearing requests. As you know, Chapter 55 of our rules provides a two-part analysis for considering requests for contested cases on TIPD's applications such as this. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case, assuming at least one requester meets the requirements. That we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. Governmental entities can establish standing if they also identify statutory authority over or another interest in the issues relevant to the application. Colleagues, our requesters include one governmental entity, Ellis County, and numerous individuals. Ellis County has demonstrated that it is an affected person, identifying its legal authority over services that may be affected by the proposed facility and articulating concerns within our jurisdiction on this application. I would also grant the requests by the Burns, the Williams, Gregory Crow, Michael Jones, Geneva Reisinger, and David Miller. I think they have all demonstrated a right to a hearing. I recommend denial of the remaining requests for the reasons that we often find. Some of the requesters failed to identify a concern that's within our jurisdiction on this application. Some failed to say how they would be personally affected, and some reside too far from the proposed facility and discharge point to be affected in a manner different from the public, especially in light of the nature and volume of the proposed discharge. So colleagues, why don't I pause there and see how you came out on part one of our analysis. Commissioner Janeka.
I'm in agreement with you so far.
I agree.
All right, turning to the issues, I would refer water quality, its effect on the health of the requesters and their families, as well as the protection of the uses of the receiving waters and of animal and aquatic life. I would also refer anti-degradation, nuisance odors, and finally the notice issue. Commissioner Janeka.
Also fully in agreement.
Commissioner Gonzalez. All right, sounds like we're ready for a motion.
I move that we grant the hearing requests of Ellis County, Betty Burns, Kenneth Burns, Gregory Crow, Michael Jones, David Miller, Geneva Reisinger, Glenda Williams, and John Williams. That we deny all remaining hearing requests and requests for reconsideration. That we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of water quality, including the protection of existing uses of the receiving waters, aquatic life, animal life, and the requesters and their families' health in accordance with applicable regulations, including the Texas Surface Water Quality Standards. B, whether the draft permit complies with applicable anti-degradation requirements. C, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code 309.13. And D, whether applicant substantially complied with applicable notice requirements. I finally move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, call the next item, please.
Item number 5 is the consideration of a resolution to appoint 3 members to serve on the Irrigator Advisory Council, and the executive director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Joseph Hopkins, team leader of the Technical Programs team with the Program Support and Environmental Assistance Division in the Office of Compliance and Enforcement. With me today is Melissa Keller, Assistant Deputy Director of the Program Support and Environmental Assistance Division. We are here today to request the appointment of 3 members to the agency's Irrigator Advisory Council. If approved, these recommended appointees will receive 6-year terms that will expire on February 1st, 2031. The recommended appointees are Mr. Remington Holt, Irrigator from Canyon, Mr. Sergio Martinez, Irrigator from Conroe, and Ms. Paula Szymanski, Public Member from Frisco. Included in your backup material are resumes for each of the recommended appointees describing their backgrounds and qualifications for their appointments. We are available to answer any questions you may have on this matter.
Thank you, Mr. Hopkins. I have none. Colleagues, any questions?
Thank you.
Seeing none. Ms. Smith, has anybody signed in to speak?
No one has signed in.
Mr. Arthur.
Good morning, Chairman, and good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. Public supports adoption of the proposed resolution.
Thank you. I want to start by thanking all of the council members for their service, and I want to thank the nominees for their willingness to serve. And colleagues, I'm ready to go forward with the recommended appointments.
Likewise.
I move that we adopt the executive director's recommended resolution filling the vacancies on the Irrigator Advisory Council as follows. 1, appoint Remington Holt effective February 1st, 2025 for a 6-year term to expire February 1st, 2031. 2, appoint Sergio Martinez effective February 1st, 2025 for a 6-year term to expire February 1st, 2031. And 3, appoint Paula Szymanski effective February 1st, 2025 for a 6-year term to expire February 1st, 2031.
Second the motion.
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That'll bring us to items 6 through 8. We'll give folks a chance to get to the table. Items 6 through 8 are the consideration of the publication and solicitation of public comment on 3 draft implementation plans for TMDLs in the Big Creek, in the Brazos River Basin, in the Cotton Bayou watershed, and in the Oyster Creek watershed of the San Jacinto Brazos Coastal Basin. And the executive director's staff is here to present these items.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Nicole Hall with the Water Quality Planning Division in the Office of Water. With me virtually today is Wyatt Eason with the Total Maximum Daily Load Program and Aubrey Pawelka with the Environmental Law Division. Today, the Executive Director is requesting to release 3 Total Maximum Daily Load implementation plans for public comment. Item number 6 on the docket is the implementation plan for 2 Total Maximum Daily Loads for indicator bacteria in Big Creek. The Big Creek TMDLs cover 2 assessment units and 1 water body within Fort Bend County. Item number 7 is the implementation plan for 1 total maximum daily load for indicator bacteria in the Cotton Bayou watershed. The Cotton Bayou TMDL covers 1 assessment unit and 1 water body within Chambers County. Lastly, item number 8 is the implementation plan for 2 total maximum daily loads for indicator bacteria in the Oyster Creek watershed. The Oyster Creek TMDLs cover 2 assessment units and 2 segments within Brazoria and Fort Bend counties. Stakeholder groups were formed with balanced representation of all interested parties for each project watershed. Stakeholders were tasked with providing input on the implementation plan documents. The development of these documents included an active public participation effort and balanced stakeholder groups coordinated by TCEQ and the Houston-Galveston Area Council. The success of these projects is due to the collaborative efforts of the individuals and organizations that put in the time to develop the documents to improve water quality in their communities. The Executive Director respectfully requests approval to publish all 3 implementation plans for public comment. Permission is also requested to make non-substantive and clerical corrections before providing the documents for public notice if needed. Thank you, and we are available to answer any questions that you have.
Thank you, Ms. Hall. I have none. Any questions, colleagues? Seeing none, Ms. Smith, has anybody signed in to speak?
No one is signed in.
Mr. Arthur.
OPIC supports approval to publish and solicit public comment on the draft implementation plans for 2 TMDLs for indicator bacteria in Big Creek, 1 TMDL for indicator bacteria in Cotton Bayou watershed, and 2 TMDLs for indicator bacteria in Oyster Creek watershed.
Thank you. Colleagues, I really, as always, appreciate the robust stakeholder process on this and all the work that went into developing these proposals. I'm ready to put them out for public comment.
I move that we approve the publication of and the solicitation of public comment on the following draft implementation plans as recommended by the Executive Director. The draft implementation plan for 2 total maximum daily loads for indicator bacteria in Big Creek of the Brazos River Basin in Fort Bend County. The draft implementation plan for 1 total maximum daily load for indicator bacteria in the Cotton Bayou watershed of the Trinity River Basin in Chambers County, and the draft implementation plan for 2 total maximum daily loads for indicator bacteria in the Oyster Creek watershed of the San Jacinto Brazos Coastal Basin in Brazoria and Fort Bend counties.
Second?
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which are items 9 through 23. And the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Sedemeyer of the Enforcement Division, and with me today are Craig Pritzloff, Director of the Office of Compliance and Enforcement, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 9 through 23. The total assessed administrative penalties are $304,874, with $55,267 deferred, $50,737 applied towards supplemental environmental projects, and $198,870 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Sedmeyer. I have none. Any questions, colleagues? Seeing none at this point. Ms. Smith, I understand we have some people signed in wishing to speak, and I'll have you called in.
I'll also acknowledge that we had someone signed in on 12 who's available for questions, and additional people on item 13 who are available for questions. But on 13, we have Lauren Ice, who's asked to speak. And to allow enough time for all of the people here today to be heard at the meeting, the commission limits initial comments from each speaker to 3 minutes.
Good morning, Ms. Ice.
Good morning. Good morning, Commissioner and Chair. Thank you for the opportunity to speak. I'm speaking on item 13 in opposition to having Ms. Lauren Ice. I'm an attorney with the law firm Brown and Ice. We submitted some written comments already in opposition to this agreed order regarding the SpaceX payload system. Those comments were submitted on behalf of several organizations, including Save RGB, the Cleveland Tribe of Texas, South Texas Environmental Justice Network, and Clean Water Action. We outlined several reasons why we're opposed to the agreed order, but the big one I want to focus on today is the fact that this agreed order proposes to temporarily authorize a discharge in lieu of or in replacement of an actual Clean Water Act permit, which is something that this agency just does not have the authority under the Clean Water Act to do. The Clean Water Act requires a permit from anybody who wants to.
Sorry. The Clean Water Act is absolute. If you want to discharge pollutants into waters of the United States, you have to have a permit to do that, and you have to meet the conditions and the terms of that permit in order to be discharging those pollutants lawfully. It does not provide an exception to that permit requirement. It also prescribes certain procedures for getting that permit that include the opportunity for public comment, the opportunity for a draft permit to be subject to a contested case hearing if affected persons request one. And those procedures are something that have not been followed with this agreed order. And so what's effectively happened is this agreed order is being used to circumvent the requirements of the Clean Water Act, and that is in direct contradiction to what the Clean Water Act requires. And this precise issue was something that was raised back in 1998 when the EPA was delegating the Clean Water Act permitting program to the state of Texas. At that time, commenters said there were concerns that the agency could use temporary and emergency authorizations to circumvent the permitting process and effectively allow degradation of the waters of the United States without permits. And the EPA answered unequivocally, no, that will not be allowed. So the situation you're faced with now, the EPA has already said no, that this is not allowed. That they cannot, and I will quote from the Federal Register, the agency will not have the authority to issue permit type discharge authorizations via emergency or temporary orders under the TPDES program. And importantly, I want to emphasize that the failure to follow the permitting program in this case is not just a procedural harm. This is a substantive harm. We do know based off of the very limited but information that is available publicly right now that the discharges that are occurring from the SpaceX deluge system are going to degrade water quality in our nation's waters. And that is based on the fact that in recent federal court filings, SpaceX has provided the results of 32 water quality samples. They've provided your agency with only 2 samples of water quality samples that have been taken. And so far of those samples, half of them would exceed the daily maximum effluent limits for hazardous metals that this staff has already calculated would be necessary to protect aquatic life uses in the receiving waters. And so we know based on the very limited data, I would represent that there is concern that the data that SpaceX has provided, those samples are not necessarily representative, that those samples do not necessarily take into account all of the pollutants or identify all the pollutants that are going to be going to be discharged into our nation's waters. But those are the kinds of questions that the permitting process is supposed to answer and is supposed to address. So just again, based on what's available right now, we know that we do not have the authority to issue temporary authorizations to bypass the permitting program. So I would respectfully request and urge you strongly to remove the provision in this agreed order that would provide for that temporary authorization and allow that process to play out through the permitting process the way the Clean Water Act requires. Thank you.
Thank you, Ms. Ice.
Those are all of the people that have signed in and asked to address the commission. We have representatives from the company who are available to answer any questions if the commission has them. And of course, staff are here too.
Okay, colleagues, any questions or comments at this point? Okay. Turning to Public Interest Counsel, Mr. Arthur.
OPIC has reviewed each of these enforcement items, including the public comments on item 13. Regarding that item, we appreciate the interest and participation from Daryl Silva, Save Our GV, the Carrizo Comacrudo Nation of Texas, South Texas Environmental Justice Network, and Clean Water Action. We also acknowledge and appreciate the ED's response. At this time, OPIC supports adoption of all the orders presented by ED staff.
Thank you, Mr. Arthur. Colleagues, I do as well. I am going to recuse myself from a different item, item 12, and I'll go ahead and move adoption of items 9 through 11 and 13 through 23 as recommended by the executive director.
Second.
The motion has been made and seconded. All those in favor say aye. 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 The motion carries. And colleagues, I will leave it to you what to do with item 12.
I move that we adopt item 12 as recommended.
Second.
And I'll just note my recusal and abstention. All those in favor?
Aye.
Sounds like that one passes too. Ms. Smith, when you're ready, I'll ask you to please call the next item.
That brings us to our quadrennial rule review, which is item 24, and that is the rule review for 30 TAC Chapter 40. And the executive director staff is here to present the item.
Good morning, Chairman. Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you is item 24, the adopted rule review of 30 Texas Administrative Code Chapter 40 Alternative Dispute Resolution Procedure. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of this chapter to determine if the need for the rules within this chapter can continue to exist. The proposed notice for this review is published on the May 31st, 2024 issue of the Texas Register with a 30-day comment period. No comments were received for this rule review. Based on the review of this chapter, the Executive Director has determined that the reason for the rules of Chapter 40 continue to exist and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule review of Chapter 40. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project manager and staff attorney assigned to this chapter are with us to answer any questions.
Thank you, Ms. Rica. I'm going to go out on a limb and say that nobody has signed in to speak on this item and turn it over to you, Mr. Arthur.
For this quad review, OPIC considered three things. One, whether public comments were received. Two, whether any rules were found obsolete. And three, whether the rules are still needed. No public comments were received and no rules were found obsolete. The Chapter 40 rules are still needed to implement the Texas Governmental Dispute Resolution Act. Further, these rules continue to offer the public and regulated community an efficient, less costly, and less time-consuming alternative to the contested case hearing process. Therefore, OPIC agrees that the reasons for initially adopting the Chapter 40 rules continue to exist, and we support readoption of these rules.
Thank you, colleagues, for the reasons Ms. Rico and Mr. Arthur just laid out. I'm ready to readopt.
I move that we adopt the rule review and readopt the rules in 30 Texas Administrative Code Chapter 40 without amendment as recommended by the Executive Director.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
The next item, is our public comment session. The commission will receive comments from the public on matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permit matters or other contested cases, which are subject to the ex parte prohibition found in Texas Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and the recitation of existing policy. With that, first call Annie Spade. I'm not seeing her here, so maybe we can come back to her. Next on my list is Errol Summerlin, who's virtual.
Yes, Mr. Chairman, can you hear me?
Yes, sir. Go ahead. Thank you.
All right, thank you. My name is Errol Summerlin, and I have a home in Portland. I'm also co-founder of CAPE, the Coastal Alliance to Protect Our Environment. I'd like to address the Commission's propensity to ignore or alter proposal for decisions issued by administrative law judges at the State Office of Administrative Hearings, or SOA, especially in applications from industry in the Corpus Christi region. When you refer a proposed permit to SOA for a contested case hearing, an ALJ is assigned, sometimes 2 are assigned. Over the course of 9 months, they hear witness and expert testimony, receive briefings from all parties, review pre-filed testimony, depositions, written interrogatories, requests for production. They hear from all parties on applicable statutes, rules, and regulations. If the judge needs clarification on something, she can certify questions to the commission on the commission's interpretation of its rules and applicable statutes. In other words, they do everything for you. They issue a PFD containing a statement of the reasons for the proposal, as well as findings of fact and conclusions of law which support the proposal on any issue referred by the commission. Thousands of pages and multiple exhibits are in the record. In every instance where the PFD recommended denial of a permit to a heavy industry, you dismissed the recommendation and granted the permit as drafted by the ED, or you altered the PFD's finding of facts or conclusions of law and granted the permit. You do so in a matter of minutes. In some cases, you listen to oral arguments, but have a prepared order ready to pass that effectively rejects the PFD. Case in point, in Corpus Christi, we have an oil refinery that began operations in 1984. In 2021, they decided they want to get into the plastics business, converting part of their operation to include a heavy oil cracker that would increase emissions from the facility across the board. The ALJ.
Mr. Summerlin, I'd like to remind you that we shouldn't be talking. I'm not sure if this one is pending still, but just remind you.
This one is, Council, this one is not pending. It is concluded, and I'm not even mentioning the applicant's name. So I'll proceed. In Corpus Christi, well, in 2021, they decided they want to get into plastics business, converting part of their operation to include a heavy oil cracker that would increase emissions from the facility across the board. The ALJs determined the applicant failed to propose emission limits that meet the best available control technology standard. Specifically, they found that the applicant failed to justify his proposed high limit for emissions of NOx from the refinery's fluid catalytic cracking unit when compared to what other refineries have achieved from their cracking units. The ALJs recommended denial of the permit. Rejecting the PFD, you change the ALJ's findings of fact and legal conclusions regarding back for NOx and issued the permit. As best I can tell, you literally copied and pasted directly from industry's legal brief. This is not an isolated occurrence when it comes to heavy industry in the coastal bend. Your bias for industrial development belies your role to protect public health and the environment, and we take exception to that. Thank you very much for your time today.
Thank you, Mr. Summerlin. We appreciate your joining us.
We have Cindy Valdez, also virtual.
Good morning. Can you hear me? Thank you. Good morning, commissioners. Thank you for your time today. My name is Cindy Valdez. I'm getting over a cold, so excuse the harshness of my voice, but I live in Ingleside, located in San Patricio County. I'm here to talk about a recent meeting held in Portland, Texas. During this public meeting, residents expressed their environmental concerns about the poor quality of air in our community, and that we are experiencing and we are currently experiencing an additional concerns about a proposed new air source review permit with hundreds of additional tons of toxic pollutants to be emitted in the air for us to breathe. The representatives in attendance were unable to answer most questions or simply chose not to answer. This ongoing lack of transparency continues to make it difficult to support projects when residents are not getting the information needed to get the comfort level required to not be scared to death about the health impacts on our families in an already heavy industrialized area and cumulative pollution that is ongoing. The decision was published and made available just a few days prior to the public meeting. It would be literally impossible to do a thorough review in that short of time. Assuming it was not done intentionally, the majority of people at the meeting requested an additional public hearing to allow residents to properly review the multiple page document and actually give comments publicly. TCEQ refused this. I don't believe it's asking too much for improved transparency and communication for our communities. We keep hearing it, but we are not seeing it. San Patricio County has no state or federal ambient air monitors. The closest is miles and miles, and not even in the wind direction of any of San Patricio's polluting industries. Yes, San Patricio County, yet San Patricio County and right next door to my community is where the #1 and #2 crude oil exporters for the entire United States are located. Also the #1 LNG exporter. San Patricio County is experiencing environmental injustice. We will continue to ask for increased regulation and ambient air monitors needed to support the health and safety of our residents. We know San Patricio County is earmarked for even more polluting industries. So at the very least, provide this county with multiple ambient air monitors. Our safety and health depend on it. I invite you to come visit our communities in San Patricio County to see for yourselves what we are experiencing. If not, think about my comment. Review the public comments from the public hearings before rubber stamping every permit that comes your way. Thank you.
Thank you, Ms. Valdez. Appreciate your comments.
Timothy Chafin. So I understand he's signed in both as virtual and in person. I'm not seeing anyone come to the podium in person, and I understand he's not logged in online. So I'll circle back. And the same goes for the next name I'm going to call, but let's see if she's online. Chantel Griffin Riley. And the next name I have, I also understand has signed in as virtual, but is not online. But I'll give it a try again. Felicity Mondragon. Or Mondragon. And then I have Stephen Medcalf, who's signed in as virtual as well.
Let's maybe return to Ms. Spade. Ms. Spade, or have you been able to join us? Let's go back to Mr. Chafin. Are you there, sir? Ms. Riley, are you there? Ms. Mondragon? Mr. Metcalf? All right, let's double check that we have our line unmuted and see if there's anybody else who's joining us virtually who wishes to address the commission. Okay, hearing none and seeing no one in the room, Ms. Smith, I'll ask you to please call the next items.
Items 26 through 29 are for closed session, but the commission will not be meeting in closed session today.
The time is 11:04. We are adjourned.